even if you're 20 years old or 30 years old, that it's never a bad idea to organize yourself in a manner that's going to keep your assets protected from the claims of creditors or banks or whatever the case might be.
Good day, my name is David Fusco, and in this show, I'm going to talk about business, finance, and how to survive and thrive in this crazy environment that we're living in today. Welcome to my show.
And in today's episode, I'm going to do an interview with an attorney in Staten Island, New York. His name is Michael Camporeale, and he specializes in elder law planning. And in elder law planning is a method where you rearrange assets to protect the assets from the claims of creditors. And in the case of elder law, predominantly the creditors would be Medicaid, and that would be claims made against that individual's and the individual's assets for resources paid out by the state for the care of an elder individual who may end up in a nursing home. The costs could be tremendous. But elder law asset protection is really no different than any other type of asset protection. Let me introduce you to Michael Camporeale, and he's going to talk a little bit in general about what happens with people's assets as they get older, what they may need to do to protect those assets, what claims can be made against those assets, and then also he'll expand upon that and explain how, even if you're 20 years old or 30 years old, that it's never a bad idea to organize yourself in a manner that's going to keep your assets protected from the claims of creditors or banks or whatever the case might be. So, Michael.
Okay, Dave, thanks for having me on your show today. Looking forward to it all week, and I'm glad we're here and we're doing this. So thank you again.
Thank you for coming.
Okay. So as Dave indicated, I am an elder law attorney that obviously specializes in asset protection from nursing homes, Medicaid planning, and obviously estate planning, which are all issues which coincide with each other. But as Dave explained, I'll talk a little bit about, obviously the proper estate planning and Medicaid planning for individuals that are getting, close to retirement age. And then I'll touch a little bit upon, doing the proper estate planning for younger individuals, which they overlap with the planning that's also done for an older individual. But the basic planning needs to be done regardless of how old you are or what your situation is in life. And I'll touch upon the reasons why that is the case.
I have a question. As you were saying that, I was thinking, is the United States, is it all unified or is it different in each state?
As far as the Medicaid laws are concerned, every state is different, okay? But what I can tell you is, luckily here in New York State, we are one of the fortunate states that actually makes the process of getting and obtaining Medicaid, or based on the way your assets are structured and so on and so forth. It's a more forgiving state than a lot of other states. So that's one good thing that we do have here in New York, which a lot of other states don't have. And that's when I talk about qualifying for community-based Medicaid, we'll touch upon that. But although that may be the case, and that was generally always the case, times are changing now, and things are getting even more difficult here than they have been in the past. But we're still considered a much better state for individuals trying to obtain Medicaid benefits.
One of the nice things New York State may have compared to other issues.
Exactly. Which most people would probably never think that was the case here in New York State, but it actually is.
Mm-hmm.
All right, so what I'll start off by saying is that everyone obviously should be doing proper planning for their estate, which the basic planning documents that everybody should have, regardless of age, and this applies to both older individuals and younger individuals. They should have a power of attorney drafted, because what that document will do, it will appoint an agent to make financial affairs and handle their financial assets in the event that they become incapacitated. And what I mean by incapacitation, I'm not talking about death. I'm talking about illness. God forbid there's a stroke or heart attack or an illness or dementia or Alzheimer's. Without having that power of attorney in place, no one has the legal authority to manage another person's assets. So that's why the power of attorney is very important. Obviously, as you get older, and the likelihood of you becoming ill, increases as you get older. However, it doesn't matter how old you are, because an individual who is, relatively young could have an auto accident, could have a heart attack, could also be stricken by an illness. So it's not really based on age. It's basically something that everyone should be doing regardless of their age. Because once again, without having that document in place, if something should happen, no one can access those, whether it's bank accounts, brokerage accounts, transacting real estate, getting a mortgage on a property, transferring a property, anything to do with financial assets. If that person is incapacitated without having that document in place, and it's regardless of whether you're married, or you have a son or a daughter or any other family member, it's not going to happen. And unfortunately, the recourse is what is called an Article 81 guardianship. That takes place, and that's the safety net. But that's a very expensive proposition. It's time consuming, and it involves the court system. It's a formal case that has to be brought, and you want to avoid that if you can. And the best way to avoid those guardianship cases is by doing the proper planning, by involving the elder law attorney to draft that, or estate planning to draft that power of attorney. In addition to doing the power of attorney, a person should also have what's called a healthcare proxy.
On that power of attorney, I mean, does that give the person unlimited powers?
Well, I mean, you could restrict it or expand it, but for Medicaid planning purposes, obviously, you want to have more bells and whistles in there to allow for the ability to transfer assets, and you want to have that ability, increased and not limited. Because if Medicaid is something that needs to be applied for, you really have to shuffle assets around in order to be able to qualify for Medicaid benefits.
So it better be someone you trust.
Exactly. You hit the nail on the head. Obviously, the person that you're going to be listing on this document and all the other documents we're going to be discussing obviously has to be somebody that you trust, whether it's your spouse, your children. That's generally the people that are appointed. There's no requirement for that, but obviously, in my practice on a day-to-day basis, that's predominantly what we see.
Just as a thought, can you bond the person so that if there's ever a problem?
As far as on the documents, there's no requirement per se, but if you're appointed a fiduciary under a trust, you could add language in there, or if it's a formal estate that has gone through the probate process, that's a different scenario. But in that situation, you can obviously get them bonded, and sometimes it's a requirement. But for general estate planning purposes, that's not something that we do. Like I said, at the end of the day, the people that you are appointing on these documents are people that you trust, and you want to make things easier for them to do, not more difficult. You don't want to put more stumbling blocks in their way, because when the need arises and there is a person that is ill and those assets have to be either maneuvered or the bills have to get paid, whatever the case may be, you really want them to be able to jump in immediately and do what needs to be done without having potential problems. Because even with these documents, sometimes financial institutions could be a little arduous in dealing with the agent, because they're not too versed, sometimes, depending on who you're talking to, when you go to a financial institution and you produce that power of attorney.
Mm-hmm.
So moving on from there, obviously that's very important because that has to deal with financial decisions. But the healthcare proxy is another important document, and that document is solely for making medical decisions. But it's the same concept. If an individual is incapacitated, and once again, we're not talking about death, if they have an illness, a stroke, a heart attack, and they are no longer capable of making their own medical decisions, the person that they designate as their agent on their healthcare proxy legally has the authority to make medical decisions. So, for example, if a person is incapacitated and they need surgery, the person that they designate as their agent will have the ability to authorize and sign off on getting a medical procedure. And it's pretty much encompasses all medical issues, just basically discussing your medical care with your treating doctor, If you yourself can't do it because you're incapacitated, you don't have the mental capabilities of doing that, the agent that you appoint will then be able to speak on your behalf and would be able to authorize medical care for you. So it's very important as well, because you don't want to have to go through a guardianship proceeding to get someone appointed to make medical decisions, just like you don't want to have to go through that to have someone appointed to make financial decisions for you. That is a safety net there for those people that fail to plan, and I have plenty of cases that I file, and come into my office every week. But you want to avoid that if you can, and you avoid that by doing the proper planning. So those are really the two. They're called advanced directives. Those are the two main advanced directives that are necessary. Now, obviously, as far as being able to protect your assets for Medicaid planning purposes, the gold standard that we use here in New York, it's called a Medicaid Asset Protection Trust. And what that document is, it's a vehicle for you to be able to move your assets into that trust. And that type of trust can pretty much hold any type of asset, whether it's real estate, brokerage accounts, bank accounts, savings accounts, pretty much anything other than a qualified retirement plan. And the whole methodology or thought process behind that is you have to do that and you have to be proactive, because we have what's called a 5-year look-back penalty period here in New York State, which basically means that this planning, which I discussed about moving those assets into that trust, has to be done 5 years in advance. So you really have to be proactive.
Each state's different?
The 5-year look back on the institutional Medicaid, from my understanding across the board with all states, is now 5 years. So that's why being proactive is very important. You cannot come into my office the day before. There are certain exclusions and exemptions, but for general purposes for our discussion here today, that's not the mindset to have, or it's not something that could readily be able one could be readily able to do. So you really want to meet with that elder law attorney like myself and do that planning in advance. Okay, so for two reasons. Number one, you have to have the mental capabilities to do the planning, which seems pretty obvious, but if you are incapacitated, you can't do Medicaid planning because legally you don't have the ability to actually put your thoughts to paper and have something done in order to plan for the inevitable, because if you have already lost capacity, legally you cannot do this planning.
So then that goes back to that power of attorney.
And that's why the power of attorney is important, because exactly, if you haven't done that planning and you have someone designated as your agent, that agent may still be able to do that Medicaid planning for you if you have not done that already. And as far as the other aspect, obviously, is because of the 5-year penalty period. If an individual has done the proper planning and has done it in a preemptive way, and they've gotten past that 5-year threshold, they will then ultimately be able to apply for Medicaid on the institutional side. And what institutional Medicaid is a full-blown nursing home. And as many people may or may not know, the cost of care for a full-blown nursing home here in the city of New York is anywhere between $15,000 to $20,000 a month. So that could completely wipe out a family's estate, and ultimately there will be no transfer of wealth to the next generation. And it happens every day. I have those meetings come into my office every week where an individual, especially a single individual, hasn't done the proper planning, and they had a heart attack, there's a stroke, they have severe dementia, Alzheimer's, and the family members now, in that situation, 9 out of 10 times that family member is already in the nursing home. So now I'm sitting down with, generally it's their children, and if they haven't done the proper planning, it's a very different conversation, and obviously it's a conversation that those family members don't like to hear, but ultimately, depending on the facts, but 9 out of 10 times, especially if they're a single individual that's in the nursing home, I have to tell them that there's really nothing that can be done, and they will ultimately have to use mom or dad's assets to pay that facility every month, basically until if the person ends up passing away within a short amount of time. There's going to be less amount of money that has to be paid to the nursing home, but sometimes people live in nursing homes many years, and we're talking hundreds of thousands of dollars that will ultimately be paid to the facility, and not be there to be ultimately, inherited by the children. So that's where the asset protection part is very important, and the timeliness of doing it in advance is the most important thing, because most people would want, whether it's, my general clients that I meet every day, they're regular people, they own a house, they may own a second house, they may have, some money in the bank and so on and so forth. But, if they worked their whole lives and paid off their mortgage, and they have a house that they would ultimately wanted to pass on to their children, if they haven't done that proper planning and they end up getting sick, then there's not going to be that transfer of wealth for that property to the next generation.
The type of trust you're talking about, is it revocable? Is it irrevocable?
Great question. And that is an irrevocable trust. And obviously the mindset behind that is that's one of the issues, or one of the things that makes the asset protection trust work. It has to be an irrevocable trust because as far as Medicaid is concerned, that's the type of trust that is necessary in order to give you that protection for Medicaid planning purposes. It's a great question, because there is a big difference.
Do you have access to the resources in there? What happens if you need, you want to?
The way it works is obviously going back to what you alluded to earlier when we discussed the power of attorney about the person that you appoint being someone that you trust. It's pretty much the same way it works on the irrevocable Medicaid asset protection trust. You have to name a trustee as a person that you generally will trust, and 9 out of 10 times it's the children that are designated. And the way the trust works is ultimately the trustee is now going to be in charge of managing the assets that are placed into the trust. So for example, if you put a property into a trust, that trustee will then be the person that is, while you as the grantor is still alive, they will ultimately be, managing those trust assets immediately. So once that trust is funded and established, you no longer have control over the assets that are in the trust. Your trustee now has control over those assets, and that's the way it works, because if you didn't have that, you wouldn't have the Medicaid protection. So that's why there's a big difference between that type of trust and a revocable trust, whereas the revocable trust is used generally only to avoid probate, which is important, but it gives you no Medicaid protection, whereas the irrevocable Medicaid Asset Protection Trust accomplishes both things. One, it gives you that Medicaid protection if it's done in 5 years in advance for institutional Medicaid. And it also avoids probate for the assets that are put into the trust. So you get the double benefit with that type of trust. And generally, that is the type of trust that, like I said, is the gold standard for someone who is basically hitting retirement age and is ready to do the Medicaid planning.
On a trust, so who's going to benefit from it? I mean, is it your people that you name in the will? I mean, who gets the benefit from the assets?
The way the trust will generally be written, and obviously the whole concept behind this is because of the Medicaid planning part, is to ultimately be able to use those assets to be inherited by your children or whoever it is that you want to designate as the beneficiary, so that ultimately those assets can pass to those individuals as opposed to having to be spent down and paid to the nursing home.
You could put any asset in a trust. Can you put pensions and IRA money in a trust?
Those are the only things that you wouldn't necessarily put into the trust, and I'll explain why. The biggest reason you wouldn't put those into the Medicaid Asset Protection Trust is because on the current Medicaid law, those are pretty much the only assets that are exempt. So as far as, if it's a qualified plan, then Medicaid does not look at those assets when you apply for Medicaid.
So you could have $10 million in
an IRA or a 401k, exactly. And they are, under New York State, they would be considered exempt. However, the income is not. So for once you hit that required age of distribution, which is 70 and a half, am I correct?
They jumped it up to 72.
Okay, they jumped it up now. That's different. So once you've hit that required age, whatever the minimum monthly distribution is on a monthly basis, that they can take, okay? So the principle is in and of itself protected under current law, but the income part is not.
So it was let's be more realistic, $1 million in there, you were taking out $5,000 a month, the nursing home gets that, or whatever, the credit
The
gets
income,
that.
yeah, whatever the only the minimum monthly distribution.
So you pass.
Unless you have it in a higher payout status, which you wouldn't do
Yeah, well,
if you were put into a nursing home.
So now you die, there's $800,000 left. The nursing home can't grab it.
Cannot
Wow.
they cannot attach the principal, whether you're in the institution or even after you die. So that is a great thing, and but it's a very limited thing. That's pretty much the only thing. But for example, if you have a house, most people would think, wow, that's terrible. Just because I own a house, I'm not going to qualify. And the answer to that is, yeah, that is an asset that can consider you being over-resourced. And that is an asset. And that's generally, obviously, most of my clients, 99% of them, that's usually their biggest asset. And that in and of itself is considered an asset that will disqualify.
I know with estate planning, one of the things you would like is, let's say mom and dad bought a house back 50 years ago for $50,000. Now it's worth $800,000. If it's in this trust, does the value get revalued at the date of death, or is it because it's in the trust and you don't have access to it? Do you lose the increase in market value at the date of death?
Great question, and a very important issue. But yes, one of the other benefits of having this trust is you do get to step up in basis, okay, which is very important because obviously, as you just explained, an individual could have bought a house 30 years ago, and just based on the numbers you used, they could have paid $50,000 for it. But no, that house, as long as it's if the person passes away, the grantor, the people forming the trust, and then if they leave it to their kids, they get to step up in basis from the date of death.
Save a lot of tax money.
A lot of tax money. So that's another benefit, and that's one of the reasons also that you have to really do the proper planning. And I say that because, an elder law attorney like myself, we know, obviously we don't know all the tax laws, but we know how a lot of the tax laws do work. We know how the Medicaid laws work. And obviously we know about how the estate laws work. So it's a combination of all three things that are necessary in order to really know what you're doing as an elder law attorney. And that's an important issue that comes up. And it has to be addressed. And I tell you that only because, sometimes in my practice, I have clients that may have come into me after the fact or later on, and they may have had a house or may have had another property, and they just went to a regular general lawyer, and that lawyer just transferred the property and didn't understand really the tax ramifications, didn't understand the Medicaid ramifications. And a lot of damage can be done in that situation based on the step up and base issue, because if they do a direct transfer to a family member, they're not going to get that step up in basis. And in addition to that, if that person has a primary home, and now mom and dad transfer their home to that son or child, and it's not done properly or not done through the trust, they now have created a capital gains problem for themselves, because that's considered investment property for them. So these are things that happen.
You were talking about so far, you need a will, you need a power of attorney. You mentioned a living will.
Yeah, a living will is also important because that's part of proper estate planning and Medicaid planning. The living will is a common law document that's created by a lawyer, as opposed to a statutory document, which the power of attorney is, and the healthcare proxy, which means statutorily under in New York administrative law that those are documents that are created by the legislature. But a living will is basically a common law document, which basically means that you are making your end of life decisions, which is important for various reasons. But most importantly, in that living will, it's you making those decisions. You're not delegating them to an agent. So it's only for really end of life decisions. So your living will say, I don't want to be resuscitated. I don't want to have a feeding tube. I don't want to have a breathing tube. If you are in a quote unquote irreversible state where basically a physician believes the situation that you're in you're never really going to come out of. And then ultimately, if you just have life support or machines that are keeping you alive, it's you telling your doctors and the whole world, your family, the whole court system that you don't want these, extraordinary measures to be kept alive. And it's important for two reasons. Number one, like I said, you are making that decision. You're not delegating that to an agent, which is very important because if anyone has had this experience, it's a very difficult decision if a doctor comes to you and asks you to now have to make an end-of-life decision about pulling the plug on your family member. Most people are going to feel very uncomfortable and conflicted about making such decisions. But if you have a living will in place, you're not burdening that family member. That decision is already made, and you made it. So that's why it's important. That's the first reason. The second reason, which is also very important, is because as I indicated, if you don't have that document in place, you may have certain family members that want life support to continue, and you may have some that may not, and there's a potential conflict there. So that could cause a lot of problems. But I remember when I was a much younger lawyer, there was a matter of Schiavo was a case that came out of Florida where that situation arose, where a woman was basically brain dead and being kept alive on machines, and her husband wanted to terminate life support, and her mom and the woman's mother and father did not. Mm-hmm. Long story short, that case went all the way up to the United States Supreme Court, and at the time, Jeb Bush was he was governor of Florida, and he had gotten involved in that case. And ultimately, like I said, that case went all the way up to the Supreme Court. Ultimately, the court ruled in favor of the husband, and they discontinued life support. But in that case, that could have all been avoided if she had that living will in place.
So even at a young age.
Correct. And yes, in that case, she was a much younger woman. I don't remember the circumstances as to how she ended up in the state that she was in, but no, she was not an older woman at all. She was younger, and that situation happened. And yes, I don't want to sound to be morbid or but I do have cases where I have younger people that run into those problems. I had a case not too long ago where a young girl was in a 21-year-old college girl was in the car with her mom, and they were in Brooklyn, and there was a police car chase, and ultimately, as a result of the police chasing the perp, I don't remember whether it was the police car that hit her car or it was someone else or the perp that hit her car. Anyway, long story short, the car was T-boned, and the 21-year-old girl was severely injured, and so was the mom. But the mother recovered, and ultimately the daughter had traumatic brain injury. And as a result, she no longer was able to make financial decisions for herself. She was no longer able to make medical decisions for herself. And in that case, we had to file what's called that Article 81 guardianship, because I now had to have petition the court to have her mom ultimately be the guardian of her person and her property, because of the situation of not having a power of attorney in place and not having a...
So it sounds like it's cheaper to be proactive and also more efficient to be proactive than to be stuck in the situation.
Absolutely. You hit the nail right on the head. And that is without a doubt, the most important thing for those two reasons, like you said, cost and also for efficiency. Because when a horrible situation arises, whether it's through an auto accident like I just described, or whether it's, mom and dad have gone on in age and now they had a stroke, or they have full-blown Alzheimer's and dementia, the last thing a family wants to have to do is have to go through all these additional hoops with having to go through a whole formal court proceeding. Like I said, I have those situations and it happens, but when you're in that state of mind, when a family member comes in there and now they're dealing with the medical issues, the last thing they really want to have to do is go through the whole, court and legal issues. But sometimes there's no choice, and I file those cases and it happens. But it's much easier on the family if that planning's already done. They don't have to actually go through a court proceeding and in those proceedings they get very expensive because there's going to be multiple lawyers involved. Obviously, the petitioner's lawyer, the family member has to pay the petitioner's lawyer. The court will also appoint a lawyer to represent the incapacitated person. And the court also appoints a court evaluator who's also an attorney to do and conduct an investigation and prepare a report and to testify in court. So right off the bat, you have 3 lawyers that are going to be paid for this type of proceeding.
A lot of hands in the pie.
And ultimately, and that's even on a simple case where there's no interfighting with the family, it's going to be quite expensive. But then if there should happen to be any disagreement in the family as to who should be in charge, then the cost in that type of case is even going to be increased even more. So, but if the proper planning was put in place, that would avoid the need to go through all those court proceedings and that guardianship proceeding. So the cost is quite expensive, whereas sitting down with an estate planning lawyer and Medicaid planning lawyer like myself, the cost is in total different ballparks compared to doing the preemptive planning or having to go through that guardianship situation. So being proactive is one of the most important things that I tell everybody when I have to educate them on this subject. That's the most important thing because under those circumstances, having the person involved in what's going to ultimately happen to their estate or make decisions for them, they're going to be involved in the process. Whereas if they've lost capacity and they no longer have the ability to do it, those decisions are going to be made by a lot of other people that they may not necessarily have wanted to. But unfortunately, that if that has to come to that, then it has to come to that. But you want to avoid that if you can.
Sounds like we live in a world filled with law.
So planning is important. That's because of the financial aspects and even the personal, the personal aspects of, what you want done.
So you want to give a little recap, because we can go on for I think, hours and hours and
hours.
And maybe we'll do something, in the same realm, the subject area. So any how would you like to just recap?
Well, to recap, the most important things to take away from this show today is being proactive. That's the most important thing. If there's anything you would take away from this today, is to really act on the information that you're being given here and actually do something about it, and taking it to the next step by giving me a call in order to be able to sit down and discuss putting a plan together for you. And as I indicated earlier, pretty much everyone should be doing their estate planning, regardless of their age or their wealth status. A lot of people unfortunately think, I got to have millions of dollars. I got to be a Kennedy to do this or to set up a trust. That's not true. That is a big misconception. Everybody that has a family, has a husband, a wife, children, owns a house, or has anything of any considerable value that will have to be passed on, should do the planning, because as I indicated, I told you the story about the 21-year-old girl. In that situation, financially, she really didn't have anything. She was just a college girl, but
It could be a lawsuit.
100%, and that's exactly, it was twofold. Exactly, it was one, to actually handle the Medicaid issues, because unfortunately, with a traumatic brain injury, that individual had to be put into a nursing home. Okay, and the guardianship was necessary because there was no power of attorney, there was no healthcare proxy, so someone had to be in charge to be able to get her into that facility. And in addition, exactly, there was a lawsuit that had to be started. And then would ultimately be settled, and years later it eventually did get settled, and the money did come into the estate. It had to be not the estate, the guardianship, I should say, and that had to be administered. So that was the other reason. But that's obviously we started talking about that, and that particular situation did come up. But obviously as a person that is older. Obviously, I end up, those are a little bit more common because people, obviously, as they get older, they get sick. But the rules apply across the board.
So being proactive is like a key thing here.
Proactivity is the most important thing, and to actually get the planning done is most important, because even as a younger individual, you should have the same documents we spoke about: a power of attorney, a healthcare proxy, a living will, and at minimum, maybe you might not have a Medicaid asset protection trust. That's really for a retiree or a person coming close to retirement age, but they should have a simple will at minimum, because if something should happen to them, if they have minor children, We sometimes put what's called a testamentary trust in a will that could make provisions for minor children if a person has minor children. So the planning applies across the board, regardless, like I said, regardless of age or financial status. Obviously, as a person starts getting older, they are going to need all the preliminary documents that we spoke about, but they should also be thinking about doing the Medicaid planning aspect of it to be able to protect those assets so that if they need to qualify for Medicaid, they could have the federal government ultimately pick up the tab of paying for that care at $15,000 or $20,000 a month and be able to pass their assets to their children, to the next generation.
So, in addition to New York State, you registered in any other states?
I predominantly practice here in New York, and ultimately, there is reciprocity now in New Jersey because I've been so busy with everything I'm doing in New York.
Lots of people here.
I still haven't made the jump to New Jersey yet. But
now, if people want to reach you, do you have an email or a website? We'll try to get it in the
Yeah. So I recommend anybody that's interested in maybe getting some more information. Obviously, my website, it's mcamporealelaw.com, and that's M, my last name Camporeale, CAMPOREALE law.com. So it's mcamporealelaw.com, and
there's links in there to reach out to you.
There's a lot of information on there, so that could obviously be a starting point. And if anyone wants to take it a step further, I generally give a free phone consult over the phone. And my office number is 718-273-4574. So if anyone wants to, take it to the next step, give my office a call. Like I said, I generally give a preliminary phone consult over the phone for free. And I'd be happy to assist anybody that's ready to that's ready to actually take the information that that's been given
At least
here
get that
today.
will done.
Exactly. I mean, but it's very important to be proactive, and I know a lot of people procrastinate. It's not something they want to do. It's something that's going to happen tomorrow, or they may not want to face it's a touchy subject, of course, which I understand. But what I can tell you is that everybody knows that the end will come someday. It could be tomorrow. It could be 20 years from now. But and more likely than not, an individual may also get sick beforehand. So it's very important. And I say that because of my own experience. I've been doing this over 20 years now. I've seen it all. And, what I can tell you from all this experience is that being proactive is the most important thing, because dealing with these issues, it's better to be able to deal with them with the proper tools. And if you have the proper planning done, you avoid having to do the running around, or having the family member having to do that running around at the last minute when we're dealing with a medical situation. And the financial thing, that's huge. I mean, that's life changing. I have clients that have come to me and have done the proper planning. And ultimately, I get them qualified. They get the Medicaid provided to them, and it doesn't cost them anything. That's the whole purpose of what I do. And I've been doing this for so long now. I'm multi-generational now.
At least you still got hair on your head.
I've started with mom or dad, and I've done their planning. And depending on their circumstances, they may have end up either needing community Medicaid, where they're trying to get an aide to come into their house, and I help them with that. They may have gone into a nursing home, and I have helped them with that. And sometimes, unfortunately, they may have also passed away. And, I took care of the estate issues. And then, now their children are coming to me, and I did their planning for them. And now I'm at the stage of my career now where, believe it or not, these individuals are now, coming in, and now I'm doing the same Medicaid planning for them that I did for their mom and dad, whether it was 10, 15,
We're all on
20
that
years.
conveyor belt moving forward.
Great analogy.
Yeah.
Yes, great
I
analogy.
appreciate it. Thank you very
My
much.
pleasure,
for all
David.
the
Great
help.
being here.
And
Thank you.
You know,
Always great to see you, and I'm glad you had me on the show today.
I'm happy that you came on. Thank you.
Thank you.
Have a great day.
Have a good day, everybody.
Thank you, everyone. Bye.